When the social justice mob wins, everyone loses. I'm Michelle Malkin. Last week, the Oklahoma Court of Criminal Appeals issued a remarkable order that barely earned a blip on the local and state press radar. The terse, 1.5-page document denied a request by two attorneys to file an amicus brief in support of former Oklahoma City police officer Daniel Holtzclaw. This hard-working, half-Japanese son of two cops is appealing his 263-year sentence and conviction, stemming from junk DNA science, biased and sloppy police investigations, and racially charged allegations of sexual assaults by black women, which all snowballed during the Ferguson and Baltimore riots of 2014. The motion to file an amicus was made by former Oklahoma ACLU chapter president and Oklahoma University Law School professor Randy Coyne and former Bush DOJ civil rights attorney J. Christian Adams. The lawyers zeroed in on the overwhelming circus mob atmosphere that violated Daniel's constitutional rights to due process and a fair trial. The issue was raised briefly by Daniel's public defender in Proposition 3 of his direct appeal. Coyne and Adams asked the court for permission to provide their insights on the facts and law. They joined together on the motion as lawyers, quote, from divergent political backgrounds who share a belief that the troubling circumstances under which Holtzclaw's case was tried to the jury violated his fundamental constitutional right to due process and a fair trial. As we showed you in Daniel in the Den, the trial, courtroom, and entire courthouse were hijacked by social justice activists. In fact, the local Black Lives Matter-style leader herself admitted that their explicit goal was to create, quote, an uproar and foment unrest.
I cannot guarantee that something would not have exploded emotionally.
Grace Franklin organized hundreds of people to support the accusers during the trial.
We had a saying that, okay, if it goes bad and we actually riot and the riot happens, okay, we're not going to do it on our side of town and they're not going to let us go to the other side of town, so what are we going to do?
Unfortunately, the trial was not televised, but over and over again, the trial transcript shows what an out-of-control zoo it was inside the courthouse. The tension was undeniable, palpable, and relentless.
Happening today, protesting a former police officer. The group OKC Artists for Justice rallied outside the Oklahoma County Courthouse demanding justice as Daniel Holtzclaw, the man accused of sexually assaulting women while on duty, sat in court. Their chant so loud at times they could be heard inside the courtroom.
Here, the trial judge Timothy Henderson notes that a juror in another case was approached by a woman who assumed she was on the Holtzclaw jury during a break and told, quote, "We need to make sure we convict the police officer." Here, Holtzclaw's defense attorney Scott Adams tells the judge, quote, "I'm sitting over by the window and there's obviously a group of people out there chanting. And I've heard, 'Give him life, give him life.' And I've heard a number of other things. And I can clearly hear it to the point I can't even hear this witness testifying. And I'm over there struggling to try to listen to it." Adams shared his frustration for the trial record. Quote, "I was hoping it would just die out, but now I don't know how they know this, but I'm up here making a record and they've just stopped as I was approaching. It's going on and off all morning. I'm just noting it for the record." Judge Henderson disclosed that after talking to District Attorney David Prater weeks before the trial, he had learned from Prater that, quote, "the organizer of the protests actually got a permit to protest. But I don't know really what can be done other than to admonish the jury to disregard the commotion." So the city granted a protest permit, facilitating the very disruptions that denied Daniel his right to a fair trial. The district attorney's office knew about it, the judge knew about it, and these government officials simply shrugged their shoulders, claiming to be powerless to stop what they enabled in the first place. Jurors were well aware of the agitation. After the trial, juror Ron Hill boasted that the chaos didn't bother him, but acknowledged that there was, quote, concern among other jurors.
I know you told me prior that you were never worried of anything getting out of hand, but were some of the other jurors concerned that things could get out of hand if the verdict didn't go the way they wanted?
There was concern, there were, people in the jury. I'm a big guy, it didn't bother me. I, had faith that everything would be good.
Coyne and Adams asked to submit a concise, less than 20-page amicus brief covering Supreme Court jurisprudence on Sixth Amendment protections and providing the court with detailed background on the, quote, inflamed relations between police and African Americans in the summer of 2014 when Daniel was accused and charged. The brief pointed out that Michael Brown was shot by Ferguson police officer Darren Wilson on August 9, 2014. President Obama ordered a federal investigation on August 16. 4 days later, Oklahoma City activists marched on the Capitol. The very next day, police arrested Daniel Holtzclaw and released his mugshot to the media, dropping a first round of 15 charges against him. The timing of the charges, Coyne and Adams wrote, reeked of an effort to spare Oklahoma City the sort of racial unrest recently seen elsewhere following police-related incidents. At trial, quote, more than 100 people regularly jammed the hallway doing interviews with the media. Daniel's lawyer warned it was, quote, literally getting nuts out there. Even the prosecutor admitted, quote, it's very, very crowded, with every reporter trying to get some soundbite from anybody who'll talk to them. During breaks, jurors, quote, would be in the same hallway as the crowd, using the same public restrooms, having to wait up to 7 to 8 minutes amid the chaos for one of the slow elevators to arrive. At least 7 people, including accuser Shardarian Hill, had their cell phones confiscated by deputies inside the courtroom or were detained and questioned by law enforcement for photographing and or videotaping inside the courtroom. Several had captured images of members of the jury. One even captioned his or her photo, quote, deputies said 180 days in jail if caught taking pics. Outside, Coyne and Adams noted it was, quote, bedlam. Lead agitator Grace Franklin yelled, 36 counts, with her followers responding, we want life.
36 counts! We want life! 36 counts! We want life!
As Daniel's trial attorney Scott Adams pointed out, the chants would stop at obviously coordinated moments. Coyne and Adams noted the protesters evidently had assistance from inside the courtroom since their shouts suddenly stopped as defense counsel rose to object or when the jury was out. In response to Coyne and Adams' motion asking the Court of Criminal Appeals to accept their full amicus brief, the Oklahoma State Attorney General's office filed what I consider a rather bizarre 11-page objection. The state complained that the amicus, which they hadn't seen, would be redundant and irrelevant and prejudicial and unfair. In a 4-1 decision, the Court of Criminal Appeals rejected the lawyers' request to submit their full amicus brief. There was no explanation. But right here, on the signature page, is a handwritten dissent by Vice Presiding Judge David Lewis. He wrote, quote, I would accept the brief and then decide this issue. If the full court had accepted the brief, which Tulsa talk show host Pat Campbell was first to post on KFAQ 1170's website, the judges would have been fully informed of just how extreme the circus mob's impact on Daniel's trial was. Quote, there is a First Amendment right of free speech, Coyne and Adams wrote. There also is a First Amendment right to petition the government for a redress of grievances. But for outsiders at a criminal trial, there is no First Amendment right to petition the jury and browbeat it into delivering one's preferred verdict. This conclusion is a warning not only about the sabotage of Daniel Holtzclaw's constitutional rights, but also about the grave threats to every citizen who runs afoul of the social justice mob. No one is safe.
36 counts! We want life! 36 counts! We want life!